The South African Bar Association is a voluntary association of LPC registered advocates operating nationally with its head office based in Ilovo Santon. With its membership drawn from all 9 provinces of South Africa, the association has seen rapid growth and is destined to become the biggest bar association in Southern Africa in years to come. The South African Bar Association is a LPC accredited vocation training provider and conducts pupillage training for aspiring advocates. The ongoing training and development of junior advocates and legal practitioners is a cornerstone value of the association, who thereby seeks to improve the quality of legal representation in our courts. The association's flagship afternoon programs have won the respect and support of the judiciary, academics, and practitioners alike. But most importantly, the association is committed to advancing the cause of female legal practitioners and is continuously exploring and supporting initiatives aimed at making this objective a reality. Membership of the association is free for practitioners starting off in the profession. It is only after the 3rd year of practice that a nominal membership fee is required. For more information, visit the South African Bar Association at www.rsabar.net. The South African Bar Association, transforming the legal profession.
Right. So, as far as Labour Court review proceedings are concerned, it touches on three important considerations. Would be the statute. There's various statutes that impacts the Labour Court's review of jurisdiction. Then there's obviously the rules of the Labour Court, and particularly the practice manual of the Labour Court. Now, we know that the Labour Court can review decisions made by any state functionary in as far as it touches on labour-related matters. Now, when review is done, in particular, we're going to look at review from a CCMA-related bargaining council arbitration awards and rulings. Those reviews are done under Section 145 of the LRA. And what Section 145 provides that any party to a dispute who alleges a defect in any of the arbitration proceedings under the auspices of the Commission, which is the CCMA and or the Bargaining Council, may apply to the Labour Court for an order setting aside that arbitration award. That application must be brought within 6 weeks of the date that the award was served on the applicant. Now, the 6-week period doesn't start from the date of the award. It's the date that the applicant receives the arbitration award. Unless, of course, the defect involves an issue pertaining to corruption. If the alleged defect involves corruption, then within 6 weeks of the date that the applicant discovers the corruption. The Labour Court's further jurisdiction for purposes of review is set out in Section 158(1) G and H. Under G, it says subject to 145, which is the review provision. The Labour Court may review the performance or purported performance of any function provided for in the LRA on any of the grounds that are permissible in law. And then secondly, the Labour Court can review any decision taken or any act performed by the state in its capacity as an employer on grounds that are permissible in law. Now, the relevant rule that sets out how the review proceedings are to proceed in the Labour Court is Rule 7A of the Labour Court. Now, Rule 7A(1) provides as follows. A party desiring to review a decision or proceedings of a body or person performing a reviewable function, justiciable by the court, must deliver a notice of motion to the person or body and all other affected persons. The notice of motion, and this is quite peremptory or obligatory, must call on the person or body to show cause why the decision or the proceeding should not be reviewed and or corrected or set aside. Call upon the person or body to dispatch within 10 days after receipt of the notice of motion to the registrar the record of the proceedings ought to be corrected or set aside together with such reasons as are required by law or desirable to provide, and to notify the applicant that this has in fact been done. And it must be supported by an affidavit setting out the factual and legal grounds upon which the applicant relies to have the decision or proceedings corrected or set aside. Rule 3, Sub-Rule 3, the person or body upon whom a notice of motion in terms of Sub-Rule 2 is served must timeously comply with the direction in the notice of motion, and that timeously means within the 10-day period. And if the person or body fails to comply with the direction or fails to apply for an extension of the time to do so, any interested party may apply a notice for an order compelling compliance with that direction. 7A5 provides that the registrar must make available to the applicant the record which is received on such terms as the registrar thinks appropriate to ensure its safety. The applicant must then make copies of such portions of the record as may be necessary for the purposes of the review and certify each copy as true and correct. 7A6 provides that the applicant must furnish the registrar and each of the other parties with a copy of the record or portion of the record as the case may be, and a copy of the reasons filed by the person or body. Now, we know, insofar as the practice manual is concerned, that that period of time has been determined to be 60 days. The cost of transcription of the record, copying, delivery of the record, and the reasons, if any, must be paid by the applicant, and it becomes cost in the cause. I don't particularly like the reference cost in the cause for other reasons which are not relevant now. Then Rule 7A8, the applicant must within 10 days after the registrar has made the record available either by delivery of a notice and accompanying affidavit amend, add or vary the terms of the notice of motion or file a supplementary affidavit or deliver a notice that the applicant stands by its notice of motion. It's only when that's done that any party wishing to oppose the granting of the order paid in the notice of motion must within 10 days after receipt of the notice of motion or the amendment or the notice that the applicant stand by its notice of motion, deliver an affidavit in answer to the allegations made by the applicant. The applicant may then file a replying affidavit within 5 days after the receipt of an answering affidavit. Now, that is sort of the timeline for when certain documents must be filed. What I'd like to visit now and deal with is the whole concept of how does then one structure an affidavit in which you bring a review application? And this is the structure that I would propose and recommend for parties to use. Obviously, the first aspect in your affidavit will be the introduction. That aspect deals with the details of the deponent, the veracity of the factual allegations, i.e. that is true and correct, etc. That's all part of the introduction of the affidavit. Then the next section will deal with what is the purpose of the application. And in that section, the applicant would then set out in brief terms what the purpose of the application is, i.e. the purposes of this application is to review and set aside an arbitration award issued by the commissioner on such and such a day on grounds that the arbitration award constitutes a decision that a reasonable decision maker could not reach. In brief, what is the purpose of the application? That's then followed by the details of the parties, setting out who the applicant is, who's the first respondent, who's the second respondent, who the third respondent is. Followed by a brief factual matrix, setting out the facts leading up to the bringing of the application. But really a brief factual matrix to assist the court in determining what the issue is and how did the issue arise. But now the most important part for me of the structure of the affidavit are the next two. Firstly, when it's a review application, there is a complaint always about an irregularity. The applicant must set out that irregularity with clear and cogent terms. So set out exactly what is the irregularity that is being complained about, whatever that irregularity might be. Then, in addition thereto, the applicant must address the effect of the irregularity on the process and the outcome. And the reason why the applicant believes the decision of the commissioner or the arbitrator is one a reasonable decision maker could not reach. Now, when you deal with proceedings, there are two elements to proceedings: is the actual process and the outcome. And if you attack the process, you must be able to demonstrate that the process did have an effect on the outcome and that it is unreasonable. Or if you're attacking the outcome, you may very well say, well, the process that was followed, I don't have an issue with. However, the outcome that the arbitrator or the decision maker arrived at is inconsistent with the process that was followed. And then the conclusion in terms of what it is that you expect the court to do. Now, you may ask yourself, who are the parties that can appear at the Labour Court in review proceedings? Now, the following parties may appear: legal practitioners, and when we talk about legal practitioners, we speak about practicing advocates, practicing attorneys. Candidate legal practitioners may appear in review applications, and when we talk about candidate legal practitioners, we're speaking about candidate attorneys, and we're speaking about pupil advocates. They have the pupil advocates obviously subject to the direction of his or her mentor and subject to the rules of the particular bar association that he or she is a member of. But candidate legal practitioners can appear at the Labour Court. Then for employers or companies, that a director may appear on behalf of the company, or a member of a close corporation may appear on behalf of the company. And in fact, managers of employer companies can appear at the Labour Court. So for instance, you might be the employee relations manager. You can appear at the Labour Court to represent your employer. Or you might be the HR manager or the industrial relations manager. You may very well appear. I remember a company once asked me to train 2 of its employee relations managers because they felt they spent too much money on lawyers at the Labour Court, and for me to teach them how to do a whole review at the Labour Court. And that is permissible because in terms of Section 160, individuals who occupy those positions are permitted to represent their companies. Then trade union and employer organization officials may appear at the Labour Court. And then individuals appearing either as applicants or respondents may also appear at the Labour Court. Now, I'm going to take a break here and perhaps we'll deal with some of the questions that the parties may have. Any of you might have, and then I'll deal with it. So AJ, I'm going to stop sharing and then hand over to if there are any questions and deal with those questions now.
Afternoon, Bart.
Good afternoon.
Arnaus. Can I just find out in regard? I have feedback here. I don't know. In regard to the issue of the recording and time frames, are there any time frames in terms of how long we need to transcribe the recording?
So the notice of motion that goes out in terms of Rule 7A1 specifies that within 10 days, the CCMA must make the record available to the registrar of the Labour Court. From the time that the registrar informs the parties, say for instance, the registrar informs the applicant on the 10th of February that the record is available. From then onwards, a period of 60 days is provided for in the rules, within which the applicant must uplift the record, transcribe the record, and deliver a copy of such portions that the applicant relies on for purposes of the review on the other responding parties. So you have a period from the date that the registrar advises you in terms of a 7A5 notice up until you file your 7A8 notices, a period of 60 days. Now, what the practice manual says, if you fail to file your record within that period of 60 days, your review application automatically lapses. So your review application, if there's failure to comply with the 60-day period, will then automatically be regarded as having been withdrawn. So you don't need to file a notice, you don't need to bring an application, or what we refer to as the Rule 11 application, because it would automatically be regarded as being withdrawn or dismissed if there's non-compliance within the 60-day period. So if you as the applicant have not made the record available within 60-day period, provided you've sought, and I'll address that now, within the 60-day period, it lapses. However, if the applicant is having regard to the time period, so the view that he will not be able to file his record within 60 days, the applicant has one of two choices, well, three typically. One, the applicant must inform the responding parties of the fact that the applicant is anticipating difficulties or experiencing difficulties with making the record available. Thereafter, the applicant should seek an extension from the other party or an agreement to extend the 60 days by whatever period that the parties may agree to. Should the other party, the responding party, unreasonably refuse or be intransigent when it comes to an agreement on the dates or the extension thereof, the applicant must approach the judge president to ask for an extension of the 60-day period on any such terms as the judge president may direct. Okay, Anas, I hope that answers your question.
It does. Thank you very much, Bart. Thank you.
Right, any other questions before I move on? Or I can certainly deal with them now. So perhaps let me throw the question back at you. So what happens if for instance, the record is simply not available? Or you have a situation where the audio recording is there, but it's not proper? Or there's difficulty in having the record transcribed because some portions of the record is clear, some portions aren't that clear. Well, under those circumstances, you would then ask that the party or the body who's responsible of providing the record constitute what we refer to as a reconstruction of the record, meaning the parties would need to get together and reconstruct the record in order for the court to have a record available. But the Labour Court will not hear a matter unless there is a proper record before it. I'm not sure if there are any questions from that. Right. Now, typically, the types of issues that the Labour Court would review and set aside might be an instance such as where a party has led evidence And when you eventually get the arbitration award, and when you read the arbitration award, you come to the conclusion, but the evidence that ought to have been considered was not considered, or evidence that should not have been considered was in fact considered, or the commissioner failed to properly assess the evidence that was presented, or the commissioner disregarded the fact that there were challenges to the evidence that was presented by a party, and the challenge in cross-examination wasn't specifically articulated and provided for in the arbitration award. Under those circumstances, you would then claim that the commissioner misconceived the nature of the proceedings, and then as a result of that misconception, it gave rise to an unreasonable result. So you would therefore say the irregularity is the commissioner ought to have properly assessed the evidence. The commissioner failed to do so. It is the requirement of the inquiry that the commissioner properly assesses the evidence. In failing to do so, the commissioner misconceived the nature of the proceedings and thus arrived at an unreasonable result. And that is what I would like to refer to it as the doctrine of Sedumo provides for, that we must be able to demonstrate that the commissioner, in arriving at his decision, and his decision being one that a reasonable commissioner would not have been able to make. Right, any further questions, if any? Ongani?
No, thank you. Like going back to the issue of the reconstruction of the record, assuming that the commissioner has notes that don't make sense, there's no record, is it permissible that any of the parties who may have recorded the proceedings either by phone or their own notes, that is considered for that record to be complete?
Yes. So, is there an additional question before I answer?
No, that's the only question, because that's the only question.
So yes, when an audio recording is not available, the parties can, as part of the reconstruction, remember the duty to reconstruct the record is not necessarily only the commissioner's duty. All the parties who participated in the proceedings may help in reconstructing the record. So what I ordinarily do, and I've done it in a matter just recently, I would say I would draft a document or in the form of a memorandum and say, this is our, let me give you the understanding. I'm acting for Ekurhuleni. Ekurhuleni is one of the metros in Johannesburg. Ekurhuleni is in a matter with one of the big trade unions called the South African Municipal Workers Union. And there is no record available. So what I then do, I consult with the whole of the IR department and the person who represented the employer at the arbitration, and I say, what was your version of what was presented to the commissioner? And I will sit with the witnesses and say, can you recall what you testified about? I'll sit with the person who represented the company, and I'll say, let's take it through. So then we'll prepare a complete document of the evidence that the applicant says it was presented at the arbitration. We then present that to the respondent, the trade union, saying, this is our assessment of the record, or what ought to constitute the record. Please comply, if you can, to the extent that you can. Please can you respond thereto in order for us to then add your version. In doing so, get to the point where we can come to an agreement about what the record is about. And in that instance, you would look at the notes of the parties, their recollection, even the commissioner's notes, handwritten notes or comments. All of that will then be considered in order to create a record. But let's assume you've done all that, but the record is still measly, it's still poor. Under those circumstances, you must then still approach the judge president to ask for direction on the future proceedings and further proceedings in the matter. The judge president then will give such direction. I personally believe, in the absence of the record, and I've got constitutional court authority to that effect, where attempts have been made to reconstruct the record and the attempts failed, and or the record is a poor version of the record, or the parties cannot agree to what the actual record should be. Under those circumstances, the matter must be referred back to the CCMA for a rehearing or the bargaining council. Right, I hope that answers your question, Bongani. Anybody else?
Thank you so much.
Right, now, I don't see any further hands. As I said, I'm really allowing you to ask as many questions as you may want to, or if you feel that is an issue, perhaps there might be an issue that you are involved with in a review that you're seeking assistance with or guidance on. You feel free to raise that with me, and to the extent that I can, I will respond there too. Yeah, don't feel inhibited. If you have a question or a query or just something that you'd like to note or wish to understand a little better about labor court reviews, feel free to do so. Anas?
Can I make a follow-up question, Bart, regarding the question that I asked earlier? In instances where we realize quite late now, that is after the 60 days that you mentioned, that we have not completed the recordings and we have not communicated with the other party, is there anything else that we can be able to do after the 60 days?
So let me deal with, before I answer that question about when the ship has sailed. There is the 60-day period in which one must act, and then there's the 12-month period that one must act. If you don't have a completed review application within a period of 12 months, your review lapses as well. So there's the initial 60 days and for the purposes of the record, and there is 12 months for purposes of all the papers in the proceedings. Now, if in circumstances where the 60 days have lapsed, you have one of two choices. One is to approach the respondent and to seek an indulgence over and above what the practice manual provides for.
Yes.
Let's assume that the party does not want to give you the indulgence. Well, then you must bring an application to reinstate the review.
Okay.
So I was acting for a bus company where we were in similar circumstances. And my advice to my attorney at that point in time was, let us go back to court and reinstate the review. Because it's automatic, your failure to comply with the 60-day period means that your review application automatically lapses. Therefore, you need to bring an application to reinstate the review. And in that particular application, all I said to the court was, the parties were, well, we were aware of the 60-day period, but there were conditions outside of our control insofar as transcribing the record and having it typed up. But because in this particular instance, it was discovered after the fact that in fact the record had errors in it. And all of those things needed to be corrected in order to put a proper record before the Labour Court. What in that instance happened is, whilst we're continuing with that application, the respondent sent the sheriff to execute. And the sheriff then started attaching for purposes of removing the buses. We then rushed to the Labour Court on an urgent basis to stay the writ of execution pending the reinstatement application. So that would be the relief that you have. But you need to act, though. You can't leave it and thinking and hoping somehow it will miraculously get back, or you would need to take active steps to ensure that for the lack of your compliance, there's an explanation, and you'll set out that explanation in your reinstatement application.
Thank you very much, Bart.
Right. Anybody else? Bongani, I see your hand is still up. If there are any other questions, I can deal with that now.
No, sorry, it's a legacy hand, sorry.
Okay, that's fine. Right, let me ask one or two of our pupils who've attended this session, what, if any of them may have questions. Godfrey, M. Sharif.
No questions from me, Bart.
Right.
Good afternoon, Advocate. I'm all good. Thank you very much for the presentation. Though I'm all good. Right.
Now, the person who's going to ask a question now is a person who I was opponents with and lost. Mr. Mkhibiso, how are you?
I'm good. How are you, Council?
Very, very, very good, Vuyo.
Yes. Thanks. So my question is this. Can the Labour Court dismiss a deemed withdrawn review application? And I'm asking this because there's authority from, I think, the High Court and even the Labour Court itself, which says that a court has discretion when a matter has been withdrawn to refuse the withdrawal and to entertain it nonetheless on the merits and then dismiss it. So there's one judgment in particular of Judge Witcher in the matter of, I think it was it Nehau? Yes, Nehau versus Minister of Health. You know, when COVID started, when the lockdown started in 2020, Nehau brought an urgent application against.
I'm getting feedback from John. Thank you, John. Sorry about that, viewer.
No problem. So as I was saying, Nehau brought an urgent application against the Minister of Health, and they were complaining about a whole lot of issues, including insufficient PPE. And the minister then responded to that application. And before the hearing, Nehau wanted to withdraw the application, and Judge Witcher refused the withdrawal. It's a judgment that you would find under the April 2020 Johannesburg Labour Court folder on SAFLI. So
yeah, you carry on.
Okay, so I'm saying that being the case, if a court can refuse the withdrawal of a matter, why can it not refuse the deemed withdrawal of a matter? In other words, is a deemed withdrawal, does it rank higher than a normal withdrawal?
Yeah. So I must confess I haven't read. I will read that decision. That you've referred to, but I acted in a matter, and by way of answering your question, in fact, before Judge Witcher as well. And I acted for Mr. Zwane, if I remember correctly, against the South African breweries. It's also a reported decision. And what happened in that particular instance, we failed, without going into the merits of the application, we failed to file the record within 60 days. And in fact, what happened was my attorney sought a further postponement of the period, and we failed to to file the record in that period as well. So we're late twice. I was acting for the employee in that matter to reinstate the review. In dealing with the reinstatement application, the court, and you can read it at your own leisure, the court held that whilst it's not going to allow the reinstatement of the review, but it will in any event consider the review application on its merits. The court then found that whilst it dismissed our reinstatement application, had it heard the review on the merits, it would in any event have dismissed the review. For reasons that I don't want to go into now. So to come back to your question, what rates higher? I think a matter where the court outrightly dismisses the application to reinstate would probably rate higher than a deemed withdrawal of the matter for reasons set out in the other judgment. I can't think of it now. If you send me an email, I can send it to you, where the court held that whilst the practice manual is there to facilitate the rules, the practice manual in and of itself cannot supersede what the rules provide for, and where there was no court order, that in those circumstances the practice manual cannot ipso facto operate as in the same manner that a court would when a court order is made. So I would submit the court can, and you and I know, Vuyo, that because the court has inherent jurisdiction to determine its own processes, it may very well be able to do even what the practice manual tells us should not be done, or in the manner which it should be done, because of its inherent jurisdiction. Right, Vuyo. I did mention that Vuyo and I were opponents in a matter, and I lost to him, and we're still friends, right, Vuyo?
Yes, we're still friends. Thanks, counsel.
Good. Let me deal with any other questions before I move on and close off the session. Right, friends, look, if there are any questions, I will deal with them. As you know, that these sessions are recorded and we keep it for reference purposes on the Bar Association website. You can visit it at www.rsabar.net. And for the pupils who attend, whilst I can't tell you which sort of path you should be pursuing, but if you can, make labor part of your arsenal insofar as the matters that you're going to be assisting your clients with. It's a very exciting field. It's a very interesting field, and as you'll see by the nature of the questions that came in now, or in the sessions that we run, it's a very prolific field for people who would like to be involved in avenues of the law that is continuously changing. like with COVID and everything else that has been happening, etc., it's a very fascinating field to be in. So I'm going to take one more round of asking for questions. If not, I'm going to close the session. Right, anything else? Vuyo, I see your hand is still up.
Sorry, I've joined through my phone, so I don't know how to take this hand off.
Okay, no, not a problem. Okay, colleagues, thank you so much for your time and for your attendance. And as I said, my email address is well known. If you have any question or anything that you'd like to follow up on or get further information about, feel free to email me and I'll make that available to you. Thank you so much for your time and for your attendance.
The South African Bar Association is a voluntary association of LPC registered advocates operating nationally with its head office based in Ilovo Santon. With its membership drawn from all 9 provinces of South Africa, the association has seen rapid growth and is destined to become the biggest bar association in Southern Africa in years to come. The South African Bar Association is a LPC accredited vocation training provider and conducts pupillage training for aspiring advocates. The ongoing training and development of junior advocates and legal practitioners is a cornerstone value of the association, who thereby seeks to improve the quality of legal representation in our courts. The association's flagship afternoon programs have won the respect and support of the judiciary, academics, and practitioners alike. But most importantly, the association is committed to advancing the cause of female legal practitioners and is continuously exploring and supporting initiatives aimed at making this objective a reality. Membership of the association is free for practitioners starting off in the profession. It is only after the 3rd year of practice that a nominal membership fee is required. For more information, visit the South African Bar Association at www.rsabar.net. The South African Bar Association, transforming the legal profession.